Alrighty, just trying to line this up, just so we the people news. One more time at it, y'all. Alright, so we don't never think outside the box. We always, uh, well, if I was perfect, I would be a god. Alright, so we never look straight forward. We always look around us, be able to protect ourselves by any means necessary. Okay? Education is the first thing we need to know to be able to protect ourselves. We got to be educated. Okay? And don't let all these other entities to just get by with things just automatically, right? Um, you got to be belligerent. You got to stand on truth. You got to stand on facts, and you got to stand on the Constitution. And then you got to fight, fight, fight. Be belligerent. Okay? So this channel right here, yourlaw.org. Okay? So I arm length, I never got the prescription part, but I have run through the deal, and they got some really good stuff in there. Okay? So uh, as if for it works or not, I never had first-hand knowledge, just hearsay. Okay? You are law, so check out the video to kind of get some insight. Okay? Uh, that being said, I am led to believe and do believe that they're really good at what they do. Okay? That being said, let's check this out. Okay? Oh, before I proceed forward, some people, like he's going to explain, right? Enter a plea. I've talked about this, right? But I also did a check mark. I talked about this before and wrote innocent. Now, if I go through the process again, I'm going to put in there me, not you, or not y'all, but I'm going to put a checkbox in there and put presumed innocent, right? Because we are presumed innocent until we go through the process of court, okay? So I'm going to put in there presumed innocent. Well, now what are they going to do? Because I made a plea, right? But I am presumed innocent. Well, that's what our Constitution said. We're presumed innocent. So now the burden of proof is still back on them. Okay? So it's just me. I'm thinking outside the box, right? I'm not walking that straight line. Let's go. Let's see here. How do we do this? There we go.
It's such a common problem that when we get accused of a crime or a traffic ticket, everybody feels like they got to enter a plea. Okay? Let me, 1 second here. I'm going to just, some people have their video up. It might be a little distracting. So I was just finishing these notes up. I'm just going to say any plea has major legal implications. Any plea has major legal implications. Now, what does that mean? You might have heard that if you go to court on a traffic court case or a criminal charge, they're going to force you to enter a plea, and that's true. They're going to try to force you to enter a plea. They're going to say you need to enter a plea of guilty or not guilty, yada yada. I can tell you, after training lots of people on criminal cases using our Slam Dunk program, which is a special criminal case consulting coaching program we have, that we've had people held up in court for over a year just on the first appearance. And then there's other things you can do to sort of deal with the case, or at least prepare to fight if you have to fight. But the key to this whole thing is entering a plea. You hear people say all the time, oh, well, just challenge jurisdiction. But most people don't have the first clue what that actually means. And this document is available in the premium member area in the downloads section where there's some downloadable documents, and the one that says start here, click on that one and you'll find this do not enter a plea document in the folder. You can sort by date to find some of the more recent ones we've added, but I suggest you go take a look at this. So what you're seeing on screen here will be available. So just be be knowledgeable about how to enter court. A lot of people, a lot of people don't actually have a clue what entering a plea means. They also don't have a clue what challenging jurisdiction means. But you do this both at the same time. So I'm hoping in this little brief instruction I can show you some ways to do that. So appearing in court amounts to submitting oneself to the jurisdiction of the court. Wait a minute. If I'm going to challenge jurisdiction, I better not appear, right? No, you better appear and do it correctly. Somebody contacted me today. Again, they failed to appear. What do I do now? I go, I don't know, because I tell you not to do that. There's a reason I tell you not to do that. It's very hard to overcome. You're going to have to go and do something. Invite yourself in, you know. But so how do you deal with this? Well, there are consequences associated with submission. And there's no notification, there's no warning, no options for opting out of such servitude. It's in violation of the law against involuntary servitude to be forced to go in and do something and say something. Okay?
Let's pause right there. What what did he just say? Back it up. Have it repeated to you. Okay? I've talked about this a couple of times. They cannot force you to sign anything, people. That's the reason why one of the people I know in Odessa never signed any papers. And they called him out. I'm not here to contract. And all that. Now, it's a family court issue, which actually has in the 4D program contract. Okay, and it says to get them to contract with you. Okay, but it doesn't say you can force them into contract with you.
So there's a term that says entering a plea of any kind as a person testifying is a person testifying against himself. You're admitting to the genius of the record. Okay? The court, through its judicial officer, takes it upon itself to enter a plea on the behalf of the defendant, right? You need to object when they enter a plea for you. All right? And then they'll try to tell you, we have to appoint an attorney to you. No, you have.
Okay, we're going to pause right there, right? I talked about ejection deny, right? You can eject, but also we think outside the box. Can you deny? I deny you to put anything for hearing on record on my behalf. Are you acting as my attorney or my counsel, judge, magistrate? Are you giving me legal advice and hearing on for the record?
Right to counsel of your choice. There's a difference between counsel and an attorney. There's some research you can do on that. But the bottom line is, if you enter a plea or you take a lawyer, you grant a jurisdiction. You can't challenge jurisdiction once you enter a plea and take a lawyer. Now you technically can challenge jurisdiction at any time, but now you got to go remove stuff and back things up. So try to remember, I didn't want to enter a plea, so I'm going to give you some tips on what you can say, okay?
We're going back right there, right? There's that key word. Do not get an attorney, right? You waived your rights. You signed a contract for that attorney to speak on your behalf. Okay? You don't have any rights at all at that time. Okay?
So I'm presenting the following facts. Okay, make no appearances. Now that doesn't mean you don't show up. You gotta come. You gotta come in. You're not gonna stand behind the bar and get yourself arrested. You make a visitation upon the court, showing within the court, standing before the court. But at no time will I ever submit to the jurisdiction of the court. I have a friend who's in prison right now who refuses to enter into jurisdiction of the court. He maintained that. They still put him through court and even sentenced him, but he missed a few other things he should have done. And but because of that, he has an appealable case. That's good. You have to create a reason for appeal. You don't just want to just say, I want to appeal. So when we talk about admitting to the genius of the court, it's not commonly used in modern legal practice. However, in the context of a plea hearing, entering any kind of plea, whether it be guilty, not guilty, or no contest, is a formal response to criminal charges and signifies the defendant acknowledgement and submission to the jurisdiction of this court. The act of entering a plea is a crucial step in the legal process, and you don't have to do it the way they want you to do it. Now, they'll push back.
Now, that being said, I'm just clarifying, right? They want you to do this. They have to have you do this. Why do you think that the judge says he's going to enter the plea for you and all that? He's got to have this done to proceed forward and set the case. Okay? This is the reason why it's very important to stand your ground on this, right? They got to have this in order to proceed forward. That is consent. I'm also led to believe and do believe that is a claim, right? Now you're taking the claim and the burden of proof off the prosecutor or the cops, right? He claimed you were speeding, but once you do this plea, now you made a claim. Okay, now they keep calling you defendant, but you still made a claim. Okay, so and you guys think about this, okay? I may have a change of thought. I may go ahead and say, I eject and I deny, right? Because you want the ejection for appeals, but you want that denied on there for the burden of proof to still stay on their side of the four corners, okay? And you want to stand on your side of the four corners.
And tell you can't, and tell you what you have to do. People will say, well, the judge said I had to. That you got to listen carefully what these judges say. That's not what they're saying.
Yeah.
Are you required to waive your right to remain silent? Well, if it's a right, then you're not required. But people do it all the time. Entering a plea is the equivalent of not remaining silent. Can you ask questions and remain silent? Yes. Remaining silent means anything you say and do can be used against you. But as long as you're asking questions, you're in a strength position. So,
yeah, and this is why I said in the past, the present, the here and now, and probably most likely in the future, right? Never answer questions, but ask questions. All right, you want clarity. You are investigating them as well as they are investigating you. Okay? Quit giving out information.
you want once you get past that gate though, and you've entered a plea, basically all that is left for you is probably to plea bargain, make a defense if you think you have a defense, negotiate a deal, whatever. All these things aren't all bad. I'm just saying though, you're limiting your options if you, one, you don't appear, then you get a warrant for forcing you to appear, and two, if you enter a plea. So we're going to give you some ideas how to enter the plea, okay?
All right, I'm going to interrupt again because this is educational, right? And this is for my behalf, and you guys can take it with a grain of salt. I'm not an attorney, not giving legal advice. Okay? Now, that being said, geez, I lost my train of thought. Let's back that up. Maybe I can do it.
One, you don't appear, then you get a warrant for forcing you to appear, and two, if you enter a plea. So we're going to give you some ideas how to enter the plea, okay? But the implications, it is the jurisdiction of the court once you enter the plea. That's people stand there and, they've entered a plea or a plea's been entered, then they try to challenge jurisdiction without doing it correctly. You end up getting just hammered by the judge. So just keep in mind, there's this, I heard this from a Supreme Court, it's a Harvard law professor, I can't remember his name, but he talked about individuals who are incarcerated there because they voluntarily agreed to be there. And that's actually, I forget which Supreme Court justice that said it too, but anyway, point is, they voluntarily agreed to there. How do they volunteer? They entered into an agreement. Guilty or not guilty, or essentially either one, or the third one, no contest, is entering into the jurisdiction of the court. You entered in voluntarily. Okay? So the plea is simply a means to submit to the jurisdiction of the court. You're submitting to it when you open your mouth and speak those words. But if they force me to, They didn't force you to answer. They didn't force you to not answer with a question. Okay? And of course, if you had an attorney standing there, he already enters the plea for you because you give him general power of attorney, which means he has full control of anything that he wants to do with you. He works as an officer of the court. Not a good thing. If you want to.
All right, so I just want to pause right here. See, I didn't even go through this whole video, so he's actually pretty much saying what I was saying. Um, I just know of him, and I knew it was going to be a good video. All right, and you see these different colors here. So when they actually fax it in there, um, before, if you write it in purple, whether you write it in blue, whatever, you want to say in there before the change of colors that this is in writing of red. This is in writing of blue. Okay? Because once you put it in there, the courts have a tendency to keep it in black. All right? Colors have meanings in law, of law. Okay? It does have meanings. Okay? Blue is some form of contract. Red is the living man. And purple is royalty. You're the kings, queens, and all that. Black is just, the courts. Um, Man, I forgot what it's called. I'm sorry. Uh, kind of like in the darkness, right? Or the courts jurisdiction, I guess, what you would say. Okay, it's a different word, but I'm sorry.
Challenge jurisdiction or avoid entering a plea. Frankly, you probably have no business in there. Okay? So entering a plea is essentially testifying against yourself. Okay? The Miranda warning states anything anyone who's being arrested may say or do, anything a person being arrested may say or do will be used against them in a court of law. And they really say will, they mean it. You even acknowledge and answer a certain way. If you stand up and respond, you're acknowledging, okay, that you're speaking. You're speaking by your motions, okay? So we can get into oath and testifying and all that, but the Miranda...
I'm sorry, this is what I was talking about, right? So when the judge actually, if you do these things or process, right, is going to go ahead and dismiss the case, you need to tell him to put it in writing of, let's see, uh, I can't believe I'm having so many brain farts, okay, with prejudice, okay? Do not accept just dismissed, okay? They can come back and try again. Without prejudice, you're going to negotiate, okay? The courts are giving you some type of time to negotiate with the prosecutor. This is the reason why you see people go in there and have case dismissed, and then the next thing you woke up and realize that you're going to jail because there's a warrant for your arrest. Well, that's because it's being dismissed. Okay? It did not have with prejudice on there. You got to order that on the document with prejudice. Or agree to the terms without prejudice. And if the judge says, I'm going to go ahead and put dismiss without prejudice, and you can kind of, I deny that. I do not want to negotiate. I am here and on the record led to believe and do believe that, I may be innocent beyond reasonable doubt, right? Or however you want to look at that, or just deny it, period. I deny that request. Okay? You guys think about how you want to write that. Okay? Many different ways.
Warning gave you the opportunity to exercise your
Shit. Sorry, y'all.
freedom of speech and your right to remain silent, but we don't do it. You have the right to ask questions. Mm-hmm. All right? You have a right to have your grievances heard.
Mm-hmm.
But what we do is we just fall into the script of the court so easily.
Mm-hmm.
Okay, so we can say things like, Your Honor, I cannot enter a plea until jurisdiction is
All right, there you go. Wish there was more, but they gotta make money. All right. Maybe a good thing to check out into. These are We the People News. Bye. Sorry about a long video.